Chapter 21. Injunctions to prevent or restrain the commission of torts in general, to restrain criminal acts. Analysis. Section 1888. Section 474. The estates and interests generally legal, the estates, interests, and primary rights to be secured by injunctions of this kind are in most instances legal, and the injunctions themselves, as a class, are frequently described as those for the protection of legal rights and interests. So far as they do thus sustain and enforce legal rights, they are, of course, supplementary to or in lieu of the legal remedies which courts of common law originally gave, and perhaps now give, by action, under the same circumstances. For this reason, the general test as stated in a former paragraph applies with special force. The inadequacy of the legal remedies is the criterion which determines the exercise of this preventive jurisdiction, and the criterion is enforced, especially by the American courts, with great strictness. Section 1889. Section 475. Kinds and classes of torts restrained. The legal remedy is ordinarily considered as adequate in cases of torts to the person, and to property held by a legal title, and equity does not interfere. There are, however, certain species of torts, in respect to each of which, as a class, it is settled that the legal remedy is generally inadequate, so that equity will generally interfere to prevent the wrong by injunction. There are other species of tort, in respect to each of which, as a class, the legal remedy is adequate, but may become inadequate, in individual instances, from their particular circumstances, so that in those instances an injunction will be granted. In the kind of torts for which the legal remedy is generally inadequate, so that an injunction is a proper remedy, the title of the injured party must be clear, the injury real, and not merely temporary or transient. They are waste, nuisance, including interference with easements, servitudes, and similar rights, infringements of patent rights, of copyrights, of trademarks, and of other intangible property rights, the pecuniary value of which cannot be certainly estimated, such as literary property in manuscript writings and goodwill. In ordinary trespasses the injured party is left to his remedy of damages, but the circumstances of a trespass to property, especially to real property, may be such that the compensatory remedy is inadequate, and a court of equity will prevent the wrong by injunction. Section 1890. Section 476. Criminal acts. In general, a court of equity is in no sense a court of criminal jurisdiction. Its primary province is the protection of property rights. Hence, an injunction will not be granted to restrain an act merely criminal, where no property right is directly endangered thereby. Thus, an act morally wrong, such as gambling, will not be enjoined at the suit of an individual, nor will a violation of a Sunday law, nor a violation of a statute, where no property rights are involved. But where property rights are endangered, the fact that the acts are criminal will not prevent the court from exercising its jurisdiction. The United States Supreme Court, in a leading case, has laid down the rule as follows: something more than the threatened commission of an offense against the laws of the land is necessary to call in to exercise the injunctive powers of the court. There must be some interferences, actual or threatened, with property or rights of a pecuniary nature, but when such interferences appear the jurisdiction of a court of equity arises, and is not destroyed by the fact that they are accompanied by or are themselves violations of the criminal law. Section 1891. Section 477. Applications of the principle. The instances of the exercise of this jurisdiction are many and various. All that is necessary is a state of fact which ordinarily gives rise to a right for injunctive relief. Thus, an injunction has been granted to restrain a criminal trespass on oyster beds, and to restrain so-called ticket scalpers from disposing of round-trip tickets in violation of a penal statute. Recently the courts have entertained many applications for injunctive relief against criminal acts by labor leaders and organizations, and the same principle has been applied. Thus, it is now clearly settled that a court of equity will enjoin the criminal intimidation of workingmen, in order to protect the property interests of their employers. Similarly, the court will enjoin strikers from committing criminal acts of violence, and likewise, it will restrain a criminal conspiracy of any number of people to injure property. These applications of the rule, while recent, are still in accordance with well-established equitable principles, and will be discussed fully and in detail in a later chapter. Section 1892. Section 478, same, public nuisance, suits by individuals. One of the most frequent applications of the principle is to suits by individuals to restrain public nuisances. It is a familiar principle of law that an individual cannot maintain a suit to abate or to recover damages for a public nuisance unless he suffers some special damage different and other from that suffered by the rest of the community. Hence it follows that equity will not enjoin a public nuisance at the suit of an individual unless he has suffered or is likely to suffer such damage as would entitle him to maintain an action at law, where the injury resulting from the nuisance is, in its nature, irreparable, as when loss of health, loss of trade or destruction of the means of subsistence, or permanent ruin to property will ensue from the wrongful act or erection. Courts of equity will interfere by injunction, in furtherance of justice and the violated rights of property. Thus, a party specially injured may enjoin the maintenance of a house of ill fame, although it be a crime to use property for such a purpose. Likewise, a person who would suffer a special injury by an explosion may obtain an injunction to restrain the criminal storage of nitroglycerin within the limits of a city. Again, an injunction will be granted to a person specially injured to prevent the removal of a wooden building from outside to within the fire limits of a town in violation of an ordinance, or to restrain the erection of such a building within the fire limits, where the act if carried out would amount to a nuisance, but the mere violation of the ordinance is no ground for relief unless the acts themselves actually constitute a nuisance. Again, an individual may obtain an injunction to restrain the criminal sale of liquor when he is specially injured thereby. In such a case a clear injury to property greater than that suffered by the general public must be shown. While, independently of statute, a private individual cannot maintain an action to restrain a public nuisance unless he has suffered special, pecuniary or property injury, it seems that there is no objection to such an action without such injury when a statute authorizes it. It is surely within the power of the legislature to designate the persons at whose suit a nuisance may be enjoined and abated. The reason for the rule which formerly obtained, that a private action will not lie for a public nuisance without special damages, was that to authorize private actions would create a multiplicity of suits, one being as well entitled to bring an action as another. But because the enforcement of a statute may create a multiplicity of actions is no ground for declaring it unconstitutional, there can be no doubt that it is within the power of the legislature to designate the person or class of persons who may maintain actions to restrain and abate public nuisances, and when that is done the action is for all purposes an accession instituted in behalf of the public, the same as though brought by the Attorney General or public prosecutor. Under such a statute, the plaintiff in the ease cited was granted an injunction to restrain defendant from criminally selling liquor, although the plaintiff could show no special damage. Section 1893. Section 479. Same, suit by government. As a public nuisance concerns the public generally, it is the duty of the government to take measures to abate or enjoin it. Hence it follows that the government can obtain an injunction to restrain a public nuisance, without showing any property right in itself. The duty of protecting the property rights of all its citizens is sufficient to warrant issuing the injunction. Therefore, wherever a public nuisance is shown, equity must enjoin it at the suit of the government. Every place where a public statute is openly, publicly, repeatedly, continuously, persistently and intentionally violated, is a public nuisance. This definition does not include all public nuisances, by any means, but it includes a class particularly covered by the principle under discussion. Injunctions obtained by the state to restrain the criminal sale of intoxicating liquors are among the most numerous of this class. Writs of this kind have been granted to restrain violations of prohibition laws, and to restrain the maintenance of gambling houses. Where prize fighting is regarded as a public nuisance, the state may enjoin individuals from taking any part in such contests, and from in any way aiding therein. Of course, cases involving purposes or in which the defendant is emptying refuse into a public stream, are clearly within the general principle. Section 1894. Section 480. same, right of government to enjoin act analogous to nuisance. While the right of the government to obtain an injunction to restrain criminal acts is not confined strictly to cases of nuisance, it would seem that it should be limited to cases closely analogous. Such relief, if applied to criminal acts in general, would supersede the criminal law and deprive parties of the right to a jury trial. Where the property rights of many citizens are involved, it is proper for the government, on their behalf, to invoke the powers of equity, and it would seem that only in such a case should the jurisdiction be assumed. By statute, it is provided that violations of the Interstate Commerce Act may be restrained at suit of the United States. Section 1895. Section 481, Exception, Libel. An exception to the general rule that equity will restrain a crime at suit of an individual when property rights are involved, exists in cases of libel. The early English cases laid down the rule as stated, and held that equity has no jurisdiction to restrain libels. It will be noticed, however, that in most cases of libel property rights are only indirectly, if at all, involved. But in cases where a man is directly libeled in his business, there is a question of property right. Realizing this, the later English cases, aided somewhat by statute, have receded from their former view, and will now restrain a libel when it directly affects business. The American states, however, have generally refused to adopt the later rule. The rule was established in cases in which no property right was directly involved, and is now so firmly settled, that it has been expressly held that libels will not be enjoined even for the protection of property. This outcome is in part the result of a desire not to place any more restrictions upon the exercise of free speech than are absolutely necessary.